Hi everyone, welcome and thank you for joining us today. I am Samantha Reddy and I'm the Legal Content Manager at LexisNexis South Africa. I've been in this position for a while, and over the years I've heard numerous complaints from various parts of the legal fraternity about the lack of proper drafting skills. I've heard complaints from judges that pleadings are so badly drafted that they are unable to determine what the case is about. Drafting of documents where they are blindly copying from a precedent, resulting in incorrect facts being included. I've also heard complaints about poor judgment writing. So badly drafted documents, badly drafted contracts, heads of argument, pleas, these all lead to costly delays. And at this present time, more than ever, we need to ensure that the wheels of justice turn swiftly and effectively. One way of doing this is to ensure that you present properly drafted documents. So I think that the timing of this webinar is actually perfect, and it's going to help you sharpen up your drafting skills. Okay, as a facilitator, I am now going to kick off with a few ground rules. Everyone will be on mute except for the presenter Ismail and myself. Advocate Ismail Hussain is going to take you through the importance of good legal drafting skills for about half an hour. Thereafter, we will have a Q&A session where you are welcome to send through your questions, and we will try to get through as many as we can in the allocated time. Please note that the presentation will be made available to you after the webinar, but the detailed commentary can be found in Practical Drafting Skills by Advocate Hussain. There is a special offer available to all delegates, and this will be made available to you at the end of the webinar. So just a quick one, some background about Ismail and I. I first met Ismail a few years ago when I attended a 2-day seminar on case management. It was a classroom setting for me after a long time, and I was a bit concerned. I'd find the content a little dry and be a little bored. However, that was far from reality. I was blown away by Ismail's irreverence, which I found so refreshing. His dry wit. He was very engaging, and he has the ability to explain very complex concepts in a simple and practical way. And he has taken that skill through to his writings and led to the success of his book. I'm going to just tell you a little bit about Ismail. Advocate Hussain is a former judge of the High Court and the Competition Appeal Court. He was a member of the IEC and is on the panel of trainers for the Law Society and Legal Aid South Africa. He currently provides training in drafting, trial technique, commercial drafting, and financial compliance courses attended by attorneys, advocates, and business. Ismail was recently approached by the LPC to redesign the PVT program, which is a prerequisite to complete before becoming an advocate or an attorney. He has authored 2 books and is busy completing 2 new titles, one of which will be published at the end of this year and the second sometime next year. In addition to all of this and managing a very busy practice, Ismail was recently appointed as Professor of Law at Nelson Mandela University. And I would like to take this opportunity, Ismail, to congratulate you again on this amazing achievement.
Thank you. Thank you.
Yeah. All right. I'm sure everybody's eager to hear from you. So I'll hand it over to you, Ismail.
Hi. Good morning, everyone. I'm used to talking to rooms full of people, but I find this more nerve-wracking that I'm talking to people I can't see. So I'll do the best I can. This is about drafting skills. What I want to do in this short webinar is not only to tell you the importance of drafting skills, but firstly, what is required of an attorney or advocate in the 21st century. And this relates to how people access and consume legal services. Secondly, I want to then take you through some methods in how to turn yourself into a competent, or to be competent at drafting. Now, let me assure you right from the start that all of you have the ability to draft and to draft on your own without the assistance of precedents. Now, let's start by looking at changing the mindset of lawyers. The way people consume legal services now is that they are focused on resolving the dispute that they're involved in. Now, we are currently having to compete with the internet for legal services. There's one area where we as lawyers can hold on to and be very effective, and that is in the area of dispute resolution. Now, when a client comes to you for to deal with a dispute, it always starts with you having to write a document. It can be a letter of demand, it could be particulars of claim, or a notice of motion and a founding affidavit. The requirement now is for practitioners to focus firmly on resolving the dispute. Your focus is on the client, and you have to resolve the dispute quickly and cheaply. We had this habit of turning the client's matter into something that's all about us, namely the lawyers. Now that has to change. The focus is on the client now. Now, this business of taking a dispute and then resolving it only 3 years later, or sometimes even 6 years later, has to stop. The high cost of litigation and the length of time it takes, that has been addressed through case management. Case management, it took a long time for it to be introduced into this country. It's been introduced in other countries like the UK, Canada, United States, Europe since the 90s. And we still haven't introduced it properly in our courts, but it's here to stay. Now, you have to consider, as soon as you draft a document, the impact case management is going to have on you. Just understand that case management is not about managing the case, it's about managing the lawyers. And the objective of case management is to resolve the substance of the dispute quickly, cheaply. And how this is done is to encourage the lawyers to identify the issue between their client and the opposition at an early stage, and then to resolve it as quickly as possible. Now, most of you may be familiar with Rule 41A, which was just recently introduced, which compels the lawyers to talk settlement at virtually every stage of the proceedings. Now, the purpose of that is to enable the lawyers to resolve the dispute as quickly and as cheaply as possible. Now, I want to take you to this slide, which is a statement from Lord Woolf, who headed the Woolf Commission of Inquiry into the civil procedure in England. They also had the same problems we have, matters taking too long and costing too much. And this is the statement which has gone worldwide and has guided case management throughout the world. And he said that civil litigation should be avoided where possible. Now, if you look at Rule 41A, it does just that. It encourages you to avoid, where possible, going into full-blown litigation. This is dispute resolution. It doesn't have to be a fight between two parties. So it needs to be less adversarial. South African lawyers, and I'm one of them, we are too adversarial. We don't cooperate with each other. We want to take points. We indulge in interlocutory applications. We don't make concessions. Now, all of that has to stop. It has to be more cooperative, less complex. Well, who makes it complex? People come with a simple dispute. We complicate it. We bring applications to discover. We have opposed motions, interlocutory applications. And 3 years later, we still haven't finalized the matter. And that's got to stop. It has to be more certain with shorter timescales. And the last two are critical. Must be more affordable, more predictable, and proportionate. One of the things that's happening now, as we speak, is that judges are not going to tolerate abuse of process where non-meritorious cases are brought to court and you use up resources just because you can. And we've focused now on the lawyers so that they can adopt this new method of resolving disputes. So the world has found out about us. They know we charge too much and we take too long. We're the cause of it. So we have to change. We want to resolve disputes. You want to listen to client. That's very important. We now cooperate with our opponents. We don't fight with them. We concentrate on the substance of the dispute. We do not occupy our time with interlocutory applications. I've seen firms of attorneys who, as a policy, want to bring interlocutory applications. Why? Because it generates fees. Well, I can tell you one thing about interlocutories. They don't resolve any disputes. They just create disputes. They create costs. Now, one of the things we've done with case management is that case managers, judges, are now beginning to avoid or get the parties to avoid interlocutory applications. Now, let's get down to writing, because it starts with writing. And as soon as you put pen to paper as an attorney, you are already representing your client, and you are going to dictate the direction in which this matter will go. Poor drafting usually results in poor outcomes, and you can't afford to do that. But I've been teaching drafting for 3 decades now. And one of the things I realized is that most of the lawyers I encounter can write. They know how to write. And drafting skills is not about how to write. It's more about what to write. The reason attorneys will run off to a precedent is not because they don't know how to write, it's because they don't know what to write. Now, when you can work out what to write, you already know how to write. You'll be able to draft. And when you draft using a precedent, 2 things happen, and they are the worst things. The first thing is you are copying someone else's work, and the content is usually not relevant to the peculiar facts of your dispute. That's the one problem. The second problem with using a precedent is that you stop thinking. Writing is about thinking. Whatever you write, you have to think before you write. But when you use a precedent, you don't have to think. You copy and paste. And that's of no use. When you write, you're writing for the judge, because the judge needs to know what happened. How did this happen? What caused the issues between the parties, and what are the issues? The other side wants to know what your claim is and be able to respond to it. Now, if you write particulars of claim badly, you're not assisting the judge, and you're not encouraging the other side to settle or to behave reasonably towards your claim. So precedence is not, using a precedent is definitely not persuasive. Using a precedent does not create the ability to draft using logic, being rational, and representing the facts of your client's case. That's what you have to do. You will be, now, I'll tell you what troubles many of our colleagues is this thing about drafting the cause of action. And that's what leads them to run off to a precedent. Most of us know that client sits down and gives you a set of facts. Your job now is to draft particulars of claim or a founding affidavit. In either of those documents, you have to disclose a cause of action. And I want to show you in this short webinar how you can do that. You can draft it correctly without having to resort to a precedent. Now remember, with dispute resolution, each case has its own unique set of facts. That alone tells you how dangerous it is to use a precedent. When you're drafting commercial documents, well, of course you must use a precedent, but not here. Let's talk about how you take your facts, turn that into a cause of action. Now, a cause of action is defined as the facts which the law recognizes as giving you a claim. So it involves two components. It involves the facts and it involves the law. Now, I tell everyone this. As a practicing lawyer, the law is not the most important component. It's the facts that are the most important. And you can test it. You never win a case based on the law if your facts do not support the legal outcome that you want. Law is only helpful if your facts support the law. Now, I've devised what I call a 6-step method. I need you to follow me here. I'll go through it step by step. Where I want to go with this, when we get to step 6, the idea is that you should already have a draft in front of you. Now, the most difficult thing about writing, as most of you know, since university, the most difficult part is to get to the first draft. Once you have the first rough draft, after that it's easy. You refine it and refine it again, and you come up with a decent document. Now, I want to show you a method where you can get to your rough draft pretty quickly. And one of those techniques is that you should learn to write as you research. You write immediately after you consult, so that as you constantly write, you save whatever you write. At the end of the whole exercise, you'll end up having to prepare your draft. You'll have a rough draft readily available. And from there, it's easy. Now, let's see how you do this. You first obtain all the relevant facts. The facts must be relevant to the dispute, which means the facts that you plead must assist the judge to resolve that dispute. So you keep out all the irrelevant nonsense that we know lawyers keep getting from their clients. Now, it's not all the facts that you have to plead. The facts, firstly, must be capable of being presented in court. In other words, don't draft a set of facts if you can't present the evidence to prove it in court. That's a waste of time. As a plaintiff, you will mostly bear the burden of proof or the onus of proof. If you can't discharge that onus, then there's no point in drafting those facts. You're wasting your time. You have to draft your client's version of what actually happened. And here's the most important thing. When your client gives you a version, test it. Ask yourself, is this plausible? In other words, is it likely to have happened? If your client's version is not likely to have happened, given the circumstances of the case, well, don't draft it. And there's a simple test. Ask yourself, do I believe this version? Do I believe the story? Now, more often than not, you get the bad version coming when you're a defendant's lawyer. And I'm going to deal with that in a moment. But whether you're for the plaintiff or defendant, applicant or respondent, the test is the same. Your cause of action must be based on a version that is likely to have happened. Your defense must be based on a version that is likely to have happened. Now, how do you do this? When you start writing, it usually starts with a letter of demand. Now, that's a dangerous document. If you write a letter of demand without knowing all the facts, you end up drafting a cause of action, which usually gets contradicted at the trial, and that can discredit your witnesses. So don't treat a letter of demand seriously. My advice is, if you don't have to serve a letter of demand, then don't. But legislation compels you in some cases. And it's only logical. If your version is implausible, you will not persuade the judge to accept it. Now, we use the adversarial system in our courts. What that means is the judge is not the seeker of truth. It's not about the truth. It's about what is likely to have happened. Judges don't listen to a witness and during hearing the witness in chief or under cross-examination, they can't work out if this is actually true. What they can work out is, bearing in mind the facts of this case, is this likely to have happened? So if you come up with a version that is improbable, you've got no chance of success in court. Now, if your client cannot give you a version that is probable, then your option is to try and settle. Don't go to court. Don't litigate. As I told you, we are not going to indulge attorneys and their clients with non-meritorious litigation. We've now become less tolerant of vexatious litigation. And the worst thing is, if your client insists, there's a risk now that as a practitioner, you might pick up a personal cost order, and you don't want that. I'm going to recommend to you that you read an article written by Owen Rogers, who is a judge in the Western Cape. It's an excellent article. It's called The Ethics of the Hopeless Case. It's a brilliant article. It was first published in 2017 in The Advocate. I would recommend that you get it. But look at what Lord Brown Wilkinson said. He's an English judge, and he was giving an interview about being a judge and deciding cases. And he said, dirty dogs do not win. What that means is, if you've got a rubbish version, you are the dirty dog. If your version is implausible or not likely to happen, that's the client who is the dirty dog. And trust me, they don't win. Okay. Now, let's go to the thinking that goes into it. The first step is for you to obtain the material facts of your case. Once you've got the material facts, you have to write it down. Write the facts down. But remember, it's got to be the facts that are relevant to the dispute. Leave everything out. Then the facts must be in a chronological sequence. Never write facts down until you have sequenced them. That's become a requirement in all our courts now. Logic dictates that if your client's version does not make sense sequentially, then there's something wrong. Okay. You need to work out what are the facts that are likely to be in dispute. That will present the basis for the issues between the parties. But here's a very important thing which lawyers tend to overlook. It's the undisputed facts. Write down and make a note of the undisputed facts. And here's a test. When you've got all the undisputed facts, and there are always a set of undisputed facts, now write down, now ask yourself, let's take the dispute and test it against the undisputed facts. And the test is very simple. Is my client's version supported by the undisputed facts? If it is not, you've got a problem. Now, let me tell you why that test is so important. It's because that's the test judges use. Judges, when they hear a trial or an application, most good judicial officers will look at the undisputed facts between the parties, and from there, using that as a foundation, will try and resolve the dispute. Now, if your version of the facts is not supported by the undisputed facts, you're going to get into trouble. Now, I told you, you are to write as you go. All your material facts, this is now after client has consulted, you've taken down the statements. And also remember, at this stage, you would have looked at all the documents. Now, I'm suggesting that you get all the available facts before you draft anything. Now, in the past, we didn't do this. We looked at the facts the week before the trial, and that results in postponements and wasted costs and so on. The new method for all lawyers is you get all the available facts first before you start drafting. That way, you will not make mistakes. You know, the lawyers have this thing, well, we could always amend the pleadings. Well, that doesn't help. Firstly, amendments are costly. And secondly, when you amend pleadings, it doesn't go away. Whatever you wrote before you amended is still there, and it bites you at the trial. So once you've written your facts down and in a sequence, this is the first step towards identifying your trial's cause of action or defense. This is a crucial step. You have to get it right. Now, I'm going to explain this. You never start drafting unless with a rudimentary knowledge of the facts. You know, we did this in the past. We wrote out a letter of demand. It didn't take long. Clients were impressed you got it out so quickly. You got a precedent and you sent out a summons. It's just plain wrong. That's the wrong technique. You have to obtain witness statements already before you send out the summons. You have to review all the documents. Don't wait for discovery. Get your client's documents in now and deal with it. The documents must be sequenced. And remember, the judge now expects you to plead the peculiar facts of your case, not the precedent's case. The second step now, having obtained the facts, you need to ask, what are the issues or disputes that rise from these facts? And that shouldn't be too difficult. Your client will tell you what caused the dispute. Your client will give you the facts. They may be, in most cases, you will have a dispute of fact that may have to be resolved. And typically, you will have a dispute of law. Some cases are resolved purely on a dispute of fact, and some of them on a combination of fact and law. I'm going to deal with the law in a moment. Now, sometimes more than one issue emerges. So you may have 3 different issues that come out of the facts of your client's case. You must identify those issues and then rank them. The most important one first, then the second, and then the third. There's a reason for that. Because invariably, when you go through the certification process with a judge, a case managing judge, they will whittle down the issues, and you usually end up with the one main issue that will decide the whole case. The key is to understand exactly how each issue arose from the facts that you have gathered. Now, I say test the issues. What I mean by that is, when you as a lawyer identifies the issues, be they issues of fact or law, always check with client. Write it down, tell client to come in and say, this is what I think is the issue. If we can prove this, we're going to succeed. Now, clients, they may be lay people, but it's their case, and they'll be able to help you. They may be able to tell you, but listen, there's a different issue, or there's a more important issue. So check it with client before you draft. The third step is to contextualize the issue. Now, there's a logical reasoning in this. I want you to follow it. Get the facts first. Test the facts. They must be relevant. They must be admissible. There's no point in presenting a version and you've got no witnesses. Or you've got a witness, but it's hearsay. Now, so you're going to test it. Now, we learned this at university, the golden rule of evidence. All relevant evidence is admissible unless excluded by a rule. Now, that's what it means. The facts must be relevant to the dispute, admissible in its form. And thirdly, there's a third test, must be probable in relation to the facts of the case. Once you've got that, you've now worked out what the issues are between the parties. So you've got the facts, you've worked out the issues, now look at the law. Now, what is meant by contextualizing is that you are going to find the area of the law that is relevant, bearing in mind the peculiar facts of your case. One thing you never do as a practitioner, don't be tempted to check the law until you are satisfied that you know the facts. Your job then is to understand the law that is applicable. Contextualizing means, what area of the law is this? Is this a contractual case? Is it a dispute over contract? Is it delict? Is it defamation? Is it family law? You need to contextualize it. Step 4, you need to understand the law. If there's legislation, understand the applicable legislation. But let's just let me get to the point. As a lawyer in this country, which is a common law, we use common law. That means the law is what the courts say is the law. If you want to find the law, look in the cases. If you want some guidance with with general principles, start with a good textbook. Textbooks also are good for giving you references to case law, but the law you're going to rely on is case law. So what you now have at step 4, you've got the facts. When you've worked out what area of the law, you go and look at the cases. Now remember, you don't need 15 judgments. All you need is the most recent decision of the highest court. That's all you need. You don't need 20 other citations to help you. They just annoy judges, and it's information overload which they don't need. The way you work this out is that for every instance of legal reasoning you engage in, you must be able to cross-reference the law or legal authority. That's the ability you need. And this is the ability you require when you're writing your cause of action. For example, if you're dealing with delict and you want to show that the defendant breached the duty of care. So what does the law say? The law will tell you that there is a reasonable standard that the defendant had to comply with in the circumstances. And if they fail to do so, then they've breached the duty of care. Now, you'll find a case that tells you that. But remember, in satisfying that requirement, you will have to satisfy it with reference to the facts of your matter. So the law on its own doesn't help you. Now, it's useful for you to write a short chapter summarizing the law. Put it in your own words. Now, here's the thing. Just stop copying and pasting from law reports and textbooks. They are of no use to you, and they are of even less use to a judge. What the judge wants is to see that you understood the law and you are able to state it in your own words on the document, and you are expected to do so briefly. At this stage, you will have now your material facts, you have the law, you will already see your rough draft taking shape. Now comes step 5, applying the law to your facts. You don't apply the facts to the law. It's the other way around. Don't use your facts and morph your facts into complying with the law. That's a mistake. The strength of your case will depend on how you make out each element of the rule based on the facts of your case. Now, let me explain that. When you draft particulars of claim, you state the material facts of your case. It's what we learned, what we used to call facta probanda. You want to state the material facts. When you read the law tells you that in order for you to succeed in respect of whatever remedy you want, you have to prove the following elements. What is meant by elements is the material facts. You would have at this stage, by step 5, you would have written down all your material facts in a sequence. The question is, if I can prove those facts, what does the law say is my remedy? That's the test. Now, you cannot identify the appropriate legal rule if you do not have a thorough knowledge of the facts of your case. So, the law is of no assistance if you don't know the facts of your case. Now, step 6, you come to a conclusion. The conclusion is, if I can prove these facts, I should get the remedy I want. I should get damages, or I should get performance of the contract. Your conclusion, first of all, must be supported by the facts of your case. So, to test this, if you go and look at a judgment, and you say, the judgment supports my case, the first thing you do as a lawyer is see that if that judgment cannot be distinguished on the facts. Because if it can be distinguished on the facts, it's not binding on the judge. At most, it might be persuasive, but it's not good authority. So it's all about the facts of your case. Your conclusion must be supported by the law. But before we get to the law, it first needs to be supported by the facts. Now, the best place to find support for a legal rule, as I told you, is the most recent decision of the highest court. And you don't need any more than that. Some of you might be aware that we have rules now in the SCA which say that if you refer to more than one authority, you have to say why. What they're telling you is that you only need one judgment. Now, here's the thing. Through the entire 5 steps so far, you would have noticed that you have to keep applying your mind. You have to keep thinking. And there's no copying and pasting. You are writing, and as you write, you think. Now, most of you know this. When you're writing something, it concentrates your mind, it forces you to think, and I mean, most of us, while writing, we get our best ideas because your mind is stimulated, you are focused. Writing does that. Copying and pasting does nothing. As a lawyer, you have to think everything through. Never accept anything on face value. Always question. Always apply your mind. When client gives you instructions, think it through. What if I follow these instructions? What are the consequences? Now, there's one rubric that many practitioners hide behind. And let's face it, we all do it. When things bomb out, we say, well, those were my instructions. Well, I'm sorry, you're not going to get away with that anymore. Judges now know that if you stand up in court and you say something that is that can't be supported, that is improbable, and if you get questioned and you say, well, my lord, those were my instructions, well, you're going to get into trouble. Okay. You must carry out a logical analysis. Where is this going, to what point? And the most important thing, if I can prove this version, where does it take my client? Does my client have enough facts to be able to satisfy the requirements of the law? If the answer is no, then you can't litigate. Easy answers are not always the best answers. And it's a human thing. Thinking is more exhausting than sensing. So in other words, don't go with gut feelings and intuition. Gut feelings and intuitions, those things must be left to prophets and sangomas and those people. You are lawyers. You don't use gut feeling and you don't use intuition. There has to be rational consideration. That requires willpower. And it's a fact. Intuitive people tend to scrutinize less. And for a lawyer, not everything that seems plausible is true. Never go with the easy answer. Test it. And the test is based on the facts of your case. Remember, you are going to be drafting these facts. Now let's look at the particulars of claim in little more detail. The cause of action is the facts that the law recognizes. Notice, it's the facts that the law recognizes. Cause of action is not the law. Practitioners struggle with this. Now, at this point, you have all the available facts. Now, take those material facts. I told you, keep them sequential. Now, number them. Write each material fact in a separate paragraph and give it a number. Then now you test it and ask yourself, if I take all of these facts, let's say you wrote 5 facts that come out of your client's version. What does the law say is my remedy? Am I entitled to claim? If I can prove these facts, can I get the remedy my client wants? Now, the problem that was experienced worldwide, it's not a South African thing, is that particulars of claim have become highly technical documents. They drafted by lawyers, and the whole idea is to play cards close to the chest. Now, for years, judges used to think, and lawyers used to think, that particulars of claim don't say much because the lawyers want to play cards close to the chest. Well, that's not the case. The reason why the particulars of claim come out vague is because the lawyers didn't know the facts when they drafted it. Now, you have to stop that. You are encouraged to plead the peculiar facts of your case. Let the judge know what happened. I spent many years on the bench, reading pleadings before walking into court. And I've hardly ever come across a set of pleadings that actually told me what the case is about. You have to wait till opening statement, and even then you might not hear. You must not be shy about pleading factual detail, especially if you're confident that this is factual detail you can prove is relevant and is based on a plausible version. Don't be shy to plead it because they assist the judge. I don't know of anyone who got penalized for giving too much information. I know that you get penalized for being vague, for giving too little information. Now, just as an aside, in England and in other jurisdictions, they scrapped particulars of claim and a plea because they're not helpful. They've become too technical. In England, for example, they scrap particulars of claim. Now the parties file a statement of claim where they actually say what happened, and they have to support that with a certificate of truth. And the defendant files a statement of defense. Also in England and in Australia and in Canada, before you go to court in a civil case, you have to swap witness statements. And that puts an end to all the nonsense. It should get here. We're a bit slow, but we'll get there. Now, particulars of claim are not meant to be highly technical documents. They must tell the judge what happened. It must define the cause of action. A plea must tell the judge what the defense is and must explain the facts which gave rise to that defense. Now, test your case by checking if the material facts you require do indeed emerge from your client's version. If your client can't prove it, now remember, we learned this at university. There's this thing called the onus of proof. Judges use it to resolve matters where it's uncertain which way to go. And judges hate giving by giving this thing called absolution from the instance because it doesn't resolve anything. Very often, the question of onus decides the case. Who bears the onus? And did you discharge that onus? Onus is very simply means, are you able to prove the material facts that you pleaded? Okay. Now, the whole step-by-step explanation, you will find it in my book, Practical Drafting Skills. Now, I usually run a drafting course over 2 days. Some of you may have attended it. And it involves actual drafting, but this is a short webinar. If you want to go and look at a step-by-step method, you'll find it in Practical Drafting Skills. Now, let's go to the plea. This is not an easy document to draft. And you know why it's not an easy document? Because 9 out of 10 times, your client can't give you a defense. That's why you have a problem. So let's see how you deal with this properly. The plea is your client's response to the material facts making up the plaintiff's claim. If your client has no response, then for God's sake, don't file a bare denial. I've read pleadings, a plea, hundreds of them, where there's no defense disclosed. It's just one denial after another. Case managers are not going to tolerate it. You will get into trouble. Now, the same technique applies to a defendant. Get the facts first. Hear what your client's version is. Now look at the dispute. Test the version. Ask yourself, is this version likely to have happened? Now, with defendants, you are often going to come across versions that are not likely to have happened. And if you plead it, you are heading for trouble. Now, where you deny an allegation of fact, the rule is that you do not do so evasively. You have to, if you say, I deny a fact, or defendant denies the fact, you then have to follow up by saying, what is the factual basis for that denial? Now, typically you'll have two types of responses that are commonly pleaded. Firstly, a denial of fact that raises a dispute of fact. For example, you'll draft defendant denies entering into a contract with plaintiff. Or you plead a defense, that's a second category, which introduces a new matter. In fact, it might introduce a new version. Defendant admits signing the contract, but pleads that the contract was induced by fraud. That you're all familiar with that. So you provide a factual basis for the denial. Now, if you can't tell a judge why you're denying the fact, you are saying, well, I don't have a response, but I'm denying it. You will not be allowed to do that anymore. It goes back to principle. You cannot go to court and waste resources if you actually don't have a defense. You are then abusing the processes of the court. Now, if you look at Rule 22, Rule 22 tells you how to plead. It'll tell you to admit a fact, deny a fact, confess and avoid, and state the material facts of your defense. But of course, practitioners make up their own options. This one is famous. The allegations are noted. It's nonsense. It's not in the rule, and it's completely meaningless. The method, again, is set out in my book. But I want to, before I leave this question, this drafting of a plea, the modern version is different to how we did it in the past. Now, most of you are familiar with how we draft pleadings, a plea. For example, we will say, add paragraph 5, and we'll deal with it. Add paragraph 6, deal with it. Add paragraph 7, and so on. That's not a good version. That's not a good way to draft a plea. How you do it now is that you take a standalone paragraph in your plea, give it a heading, defendant's response, and set out all the material facts of your defense in one paragraph. Judges absolutely love it, because now, instead of scattering your defense across 10 pages, you've got your defense in one paragraph. And it also makes drafting the plea quite easy, because now you just cross-reference to that paragraph and you admit, deny, or confess and avoid. So it is very persuasive. But there's a problem with this technique. It is only available to you if your client has a defense. If your client doesn't have a defense, you can't draft like this. In fact, you shouldn't be drafting a plea. You should be talking settlement. Okay. Now, I've run out of time, but we've got to this in good time. This webinar is too short for me to take you through drafting for motion proceedings. Maybe we can do that some other time. But I want to what I want to say to you is, if you can draft particulars of claim and a plea the correct way, in a manner that is persuasive, what I want, you will be able to draft a founding affidavit easy, not a problem. But what I want to say to you is that, for God's sake, have a go yourself. Write on your own. If you need to check it against a precedent, well, do so, but please write on your own. You'll never get the skill. You will never learn the skill if you don't draft on your own. Now, there are two things you need. You need method, and you'll find that method in the book, but there's something else you need. Vital, absolutely essential. You need very powerful literacy skills. You cannot draft well if you are wanting for literacy skills. Where do you get it from? Easy. You should be reading a book a month. The international standard for graduates is you should be reading a book a week. But for South Africa, that's a bit asking too much. Let's go for one book a month. Read any book, but you must read. That's what improves your literacy skills, and that's what's going to make a good lawyer out of you. When you stand up in court, you will be able to articulate your thoughts in such a manner that it persuades the judge. That's what you do as a lawyer. When you write in order to persuade the judge. You can't do that with poor literacy skills. So those of you who are serious about practice and about practicing law, read a book a month at least. You should go up to reading 2 to 3 books a month. Now, writing is exciting. I know it doesn't sound right, but it's very interesting, it's challenging, and it is most rewarding if you draft your own particulars and you get it right. You can charge a fee, your client is happy, you win the case, there's nothing better. Okay, so I'm going to end the session now and say thank you for attending. I'm going to hand you over to Samantha.
Thank you, Ismail. Thank you very much for a very interesting and informative presentation. Thank you, everybody, for your attendance. I'm really sorry we have run out of time, but we will send through a Q&A with all of the questions answered. I'll say thank you very much once again. Ismail, thank you. Thank you, participants.
Thank you.